Good day. How nice to see you all. 10 months in, 7 key cases. We're here to talk about what's happening. Let me introduce my colleagues, same as before, with lots to share, have been involved in some of the cases that we're going to talk about. Johan Ho, formerly a solicitor in a city firm specialising in commercial and construction disputes before transferring to the bar. Ruth Keating, a dual qualified barrister called to the Bar of England and Wales and Ireland, specialising in commercial and construction disputes. And Philippe Kuhn, who specialises in cross-border commercial and construction disputes as well. So, has it been for you, as one of the commercial court judges has said, an exercise in simplifying the process of preparation and shortening the process of review and finalisation? That's what he's said. What we're going to do is take you through 5 topics. We've got 5 questions. Let me give you the signposts. We're going to answer these questions. Have there been changes to the practice direction? What is now acceptable in witness statements? What should the list of documents contain? When and what sanctions are being imposed, including what's being struck out in witness statements? And how and when should issues about witness statements be raised? And when I say we're going to answer them, we're going to tell you what the current indications are as to the answers to those questions. That's a typical barrister's segue. But it's important to appreciate that we're very much in a process of learning. We're at the start of the journey of the implementation of this. And we can already see how the experience of trials may start to change some of the answers that we're going to be giving. We very much want you to participate as ever. We've got the Q&A if you want to submit a question that's just there for us, and we'll pick them up throughout the course of this webinar and also at the end. We also have the chat box. So please, you use both. We're monitoring both. It's a sharing dialogue. Just know that if you put something in, it's going to be recorded and it's going to be available. Hope that's not now immediately meant that everyone's hands have moved away from the keyboard. Please do participate as well. Can I, before I move to the first question, also add this, because I was rightly challenged by my colleagues last night, because I had started to talk on LinkedIn about the application of this to the arbitration space. And it's important to appreciate that we will be technical, we will be talking about the statement of best practice, we will be cross-referring all the time to Practice Direction 57AC, but it's a universal concern. For anybody who is involved in the dispute resolution process, we think that what is happening here is an indication of how to prove your case, whatever dispute you're involved in, before whatever tribunal. The fallibility of memory is not something unique to the business and property courts in England and Wales, and it is a recognised issue globally. You've only got to read the ICC report, which has covered the same grounds, to see that concern. Now, obviously, each dispute resolver will strike their own balance. It's going to decide upon the cultural framework, it's going to decide upon the procedural framework and the case itself as to how they will solve that problem. But they know they're going to need to, and what we're sharing with you is the particular concerns and remedies that the commercial court and the business and property courts more widely have identified here. Worth thinking about. Please share any thoughts as to how far you think this can transfer to other jurisdictions, other dispute resolution processes. Anyway, enough from me. I always do that, talk far too much. Johan, question number 1. Changes in the practice direction, have there been any?
Well, the short answer is no. PD57AC is still bidding in, and as far as we're aware, there have been no formal changes. What we have seen is a raft of authorities that have been clarifying its application and shedding light on emerging court practice across different parts of the business and property courts. What we've also seen, and I think this is part of the theme of the PD57AC being a cultural change, is in the recent updated commercial court guide, now in its 11th edition, was published earlier this month. It now expressly refers to PD 57AC and states that unless the court directs otherwise, it will apply, and witness statements for trial bundles should be prepared in accordance with it. So there's very much a cultural change that is your starting point, your default position in the commercial court, in the BPCs.
And I'd like to come back to the commercial court guide and how that has changed in the last month, perhaps when we're talking about how we get this narrative in front of the trial judge. Ruth, has the application of the practice direction extended?
Yes, Marion, so it has. So practice direction 57AC now applies to specialist admiralty claims in the Admiralty Court as well. And that's as of the 1st of October 2021. So they're a very explicit expansion of the practice direction. In less obvious ways, there are also judgments where the principles in the practice direction were taken into account. And that's even though they were cases where it wasn't strictly within the confines of the Business and Property Court. So one example of that that's worth flagging is the case of Jackman and Harold Firth. It's a 2021 decision of the Queen's Bench Division. And in terms of the background to that case, it concerned a fatal mesothelioma claim that went to full trial on liability in the QBD. But what's really interesting about that judgment for our purposes is that His Honour Judge Bird said, and I'm quoting here, although the practice direction and its appendix apply to proceedings in the business and property courts, the following principles set out in the appendix are of universal application. And then what the judge went on to do was he emphasised some of the driving factors behind the practice direction. So a mental record of a witness is not fixed in time. Memory is a fluid and malleable thing, and it's vulnerable to being altered. So Marion, reflecting your point on arbitration, again, very much a cultural shift we're seeing, even if the practice direction doesn't literally apply to that case.
And can I just say for anyone listening, don't worry, we're going to circulate to you all a list of the case references that we are using in this session. Let's pick up on that idea of the influence extending, because I think, Johan, you've been involved in one of the cases which has been picked up where there's been a development as to how we're going to be using the practice direction.
Yes, that's right. So there's a case called the Sky's the Limit Transformations Limited and Mirza. And that was, it's a high court citation, but in fact was actually a county court case. And what happened in that case is the court used the judgment as a vehicle to give general guidance on what is, or suggestions on what is a much more streamlined approach for relatively small value domestic building disputes in the county court. And even in that context, suggested that compliance, strict compliance with PD 57AC ought to be the norm. It was quite an unusual case. It involved a 5-day trial, 8 expert witnesses, all giving live evidence. So it had many hallmarks of a high court case, despite it being in a county court. And it may be in that light that case featured PD 57AC. I think the two important takeaways from that judgment are, number one, the general guidance that the judge suggested it should apply to county court cases, at least for in the TCC or construction context. And number two, this was in the context of the judge giving guidance on how to make the process more efficient and cost effective. So there's a very clear message that the use of PD 57AC is wholly compatible and in fact may encourage efficient use of costs. It is not intended to ramp up costs. It is simply how you draft your witness evidence, and it shouldn't cost a lot more than, or indeed any more than an ordinary witness statement before the rules came into place.
In fact, that's a case involving, it's a residential construction dispute with, how much was at stake? 60,000, was it?
60,000.
Yeah.
Madness.
Yeah. And what he's talking about is setting up a new regime to ensure access to justice for those involved in that sort of dispute. So let's move on. Can we have a look at what's now acceptable in witness statements? Question number 2. And I think while we're getting the detail up on that, because I think we're going to got some examples. Philippe, can I ask you, what are the courts said about the wider purpose of 57? Because I think if we can understand the policy and their statements on wider policy, it's going to make it easier to make those individual decisions.
Certainly, and the starting point is that the authorities and everything leading up to PD 57AC make clear that this wasn't intended to change the law as to admissibility of evidence at trial or overrule previous authorities on what evidence may be given. The idea essentially is to deliver an evidence in chief on paper and move away from a long recitation of all documents and background. And the mischief that's really being tackled is to avoid narrative, commentary, and argument in statements. And a good example of that point is Mansion Place. And it's also addressed, that Mansion Place was a TCC case. And then we also have in the commercial court Sir Michael Burton saying the same thing in Mad Atelier, which was one of the first, if not the first, true PD57 AC guidance authority. And he said the wastage of costs incurred by the provision of absurdly lengthy witness statements, merely reciting the contents of the documentary disclosure and commenting on it, was one of the things, or if not the key thing, that this PD was meant to stamp out.
So no narrative. If you find yourself writing into a draft witness statement an account of the emails, pause. That's, I suppose, is the first that first amber light that's coming over the hill, or we're going over the hill towards. And Ruth, at Blue Manchester, any other indications as to the particular mischiefs that the court are identifying?
Yeah, so in terms of the mischief that the court is trying to stamp out, the first, and I think one of the most interesting examples that His Honour Judge Stephen Davies raised in Blue Manchester was how some statements can be worded in a very similar way on particular issues. I think it's something we've all seen before. And it's worth pointing out what the judge said at paragraph 25. He said, "It's difficult to see in my judgment how this could ever occur if the requirements of PD 57AC are conscientiously complied with." So again, Marion, not something there that's simply an aesthetic. He's saying it's going to the very root of how that statement was prepared. And what he then went on to do in the judgment was he went on to choose examples from two witness statements, and he noted the strong similarities in the wording used. It's also worth emphasizing a final point on that, Marion, and that's that he said that the fact that a legal representative is permitted to take primary responsibility for drafting a witness statement, which is of course in no way unusual, that can't justify departing from the clear requirement that the witness statement should be, where practicable, in the witness's own words. So again, something that's really going to have to be a cultural shift, I think, to keep that at the forefront of your own mind if anyone on this is drafting a witness statement.
And what tools have the courts emphasised for ensuring compliance? I mean, how do we make sure we're getting it right?
Well, in Mansion Place, what Mrs. Justice O'Farrell stressed is that parties and their legal representatives should use the statement of best practice as a checklist. And it's not every day that a practice direction comes with an appendix telling you this is what you should do. So that's certainly well advised. And using the checklist will ensure that witness statements they produce for trial are evidence that the witness would give as oral evidence in chief. So that I think is very helpful guidance. In addition to that appendix, there is in Blue Manchester a very helpful appendix to the judgment that gives examples of what is bad practice and what needs to be taken out. We'll be coming back to that later in this webinar on examples there.
And I wanted to pick up on this idea of if we're making a list in our minds as to what we should and shouldn't be doing. We know that we mustn't be we should be pausing when we're doing the narrative from the emails. We know from what Ruth was saying that if you find you're using the same words, pause. There is a case recently where not only was the same wording used in the written witness statements, but the witnesses under cross-examination gave the same worded answers, which you might think, as indeed the judge did, was a small giveaway. And I think we've also had some indications, Philippe, about the how far you should go in identifying the source of information. Can you help us with that?
Yeah, I think the starting point is that you've got to be a bit pragmatic about this, and it depends on the issue at stake, and you also have to work with your witness. You can't introduce specificity where they're unable to give it to you, and if anything, you might have to be candid about that if it's a faint recollection.
It's not a great start, though, is it? I have a very faint recollection of this.
I came across that recently, hence the example. But in terms of more specific guidance, again, we come back to His Honour Judge Stephen Davies in Blue Manchester, and he had this to say. He said he was prepared to accept, in the particular instance there, that he could make an educated guess as to the source of knowledge, and he thought it was some combination of general recollection of events, some reference to contemporaneous documents, and so on. But he said that's not the judge's task. The statement should put beyond any doubt what the sources are, and indeed if they're a combination. And a judge shouldn't have to make a guess. And that's not necessarily in every paragraph listing out, I've had regard to the following, but weaving in key sources into what you say in the statement, I think is the practical way of approaching it.
I think, in fact, the judge said all you need to do is at the beginning to explain the strength of the recollection and how you have produced the statement, to what extent your memory has been refreshed. And provided that's there, the tenor seemed to me to be the court will work with you. But what it doesn't want is guesswork. It doesn't want, as a judge, to have to guess. And it appreciates that what's going to happen in cross-examination is that time is going to be wasted establishing the extent to which this witness is talking from their own personal recollection. And that time has got to be taken out of the court and be spent in the preparation. It's an interesting question in the chat about the effect of this on budgeting, which I'm sure we'll be picking up when we come to the question session. Let's now have a look at some specific examples from the Blue Manchester case. And while Ruth's getting that up, as everyone said, there is an appendix at the back of that where the judge deliberately produced the statements in table form indicating his ruling in relation to the objections that was made. Now, we're going to take into an in-house, both in 39 and also into a number of solicitors and other institutions, a session where we work through that because we think there's an awful lot to be gleaned out of that. But we'd like to take just a few examples with you. Ruth, take us through the first one.
Thanks, Marion. So everyone should have on their screens there the first example that I've picked out. I won't read the excerpt in its entirety, but just to pick out some of the language that's relevant moving through it. So the statement starts to say CCCL was involved in the project from the outset. The intention from the outset was that the contract would be negotiated between the two parties named. And what that section of the witness statement then goes on to say is that negotiations between CCL and Beetham took place throughout 2003. CCCL released a series of individual tender packages, and we then get a description of what that tender package incorporated. So the final section of that witness statement paragraph says the tender packages incorporated designs, specifications and reports and other consultants, and included a specific package relating to the external envelope of the building. Those tenders were open book, and all of these parties were involved in the review, an agreement of tender package information and tender return. So with the benefit of 2020 hindsight, of course, certain things do pop out about that statement, I think, even in the way that I've read it. But again, Marion, as you said, we've got this really helpful appendix at the back of the judgment, and I would encourage everyone to read it because it really is a practical tool in showing us, in at least some high-level terms, what's in and what's out. But what His Honour Judge Davies' advice was in respect of this statement, and it's short, but it says a lot. He said, reword if able in first person to confirm personal knowledge. And he said, otherwise remove or unjustify inclusion. And in swear brackets, again, we have one of the cardinal rules now, I would say, in terms of witness statement. It then says standard first person requirement. Explain whose intention it was from the outset. So it goes back to what Philippe was saying earlier. There are ways of weaving into this information. But as you said, Marion, the guesswork can't be left to the judge. They want to know, is it personal knowledge? If it is your personal knowledge, where did it come from? And that experience is so important in terms of drafting that witness statement, and something that's very much flagged in this appendix.
Because when you look at it, there's no I in there.
Exactly.
It's all third person. And it sets out the intention from the outset. That was the peg that you picked up at the end, wasn't it? Whose intention? And in particular, was it this witness's intention? I seem to remember being taught it wasn't polite to constantly talk about I.
We might need to change that now. We might need to be impolite, Marion.
Yeah, let's have a look at the next example. Is that Johan? Are you taking the next one?
Yes, that's right.
Perhaps we'll let everyone. Are you going to take everyone through it, or should we let them read it?
Yeah, I think if we just have 10 seconds to have a quick look at that, what's written there. So I think, again, if we apply the I test, we can see there are very few I's in there. The first sentence is just description. One party was asked by another party in an email dated X for content. And then second sentence, I discussed this email with my colleague, Nick Fleming, and he wrote, then describes what the colleague did. And then towards the end, they continued to be copied in on minutes and correspondence by CCL. And the judge was not very impressed with this, and his comment was all irrelevant and unnecessary reference to documents must be deleted, especially since addressed by Mr. And then he referred to how it was especially since it was addressed by Mr. Fleming, who was giving direct evidence, save for, and he gave certain exceptions to that comment. Now, this is this passage here is an abridged version. It doesn't include the save for bits. So it may well be that none of it, or very little of it, is actually properly admissible within PD 57 AC. I think arguably the second sentence where it says, I discussed this email with my colleague, Nick Fleming, but if Nick Fleming is giving evidence, and if that isn't contested, then he may very well be the person to speak to it, and you don't need anything else. So I think the takeaway is that while this may be standard text in a old style witness statement, most, if not all of this should go under PD 57 AC.
Because the judge talked about taking away from lawyers their comfort blanket of setting out the story that chains of emails reveal. He just doesn't want that in there any longer. And it's learning to trust the judges that they will find it elsewhere and that you'll be able to give it to them in the form that they can use when making their decision and writing their judgment. Philippe, are you going to take the next example?
Yes. And I think, again, I'll leave the audience to just skim read it, and then we can look at it in more detail. I think to start on this, what struck me about it, and this ties in with what the judge had to say, is the level of detail here. This is quite technical evidence, and the omission, and this is what the judge criticized, is that the witness hasn't specified the source of their belief and their understanding. And I think particularly if you look at the penultimate sentence, that's a classic example of where there should be, I think, some reference to the source of knowledge. I understood that DRYLAC 58 was being applied to external elements of the framing. How do you understand that, would be the question there. And then assumed that DRYLAC would not be used on the SPO framing. Again, the reason for the assumption isn't spelled out, and I think you can find that in other parts of this as well. And as a sort of personal example, I recently had a witness who was trespassing into giving IT expert evidence, and we had to draw it. We didn't have an IT expert because we didn't have permission for it, and we had to draw a distinction between things that someone could reasonably know and things that are just too specialist for them credibly to know, even if they went away and researched. And at least to me, this passage is probably on the wrong side of the line, and in any event didn't specify the source of knowledge.
And that was in the context, as I understand it, of a witness statement that hadn't grappled with that issue generally.
Yes.
Because what I don't want anyone to go, I mean, or should they be going away with the idea that you put that general statement in of sources of belief and strength of recollection, and in addition, each time you've got to add it. Is that necessary, or is it enough if you frame it correctly at the beginning?
I mean, I think this is maybe a matter of preference, but I think you have to take a contextual approach, and I think I would be a bit reluctant, especially in a long statement that may cover many different areas, or although maybe the statement shouldn't be that long in the first place. I think where there are particular points that would leave the judge or anyone else reading it in doubt as to how you might know, not already covered in the general sort of source of knowledge part, I would put it in, but not to the point of laboring it and, you know, sort of making the statement unreadable by doing it in every sentence or every paragraph unnecessarily.
Okay, well, let's try, those examples are useful. Can we take those down and let's just try and pull together what we've got specifically from the case law. I think, Johan, have we got any further guidance about the excessive use of witness statements for comment?
Yes. So a lot of the examples we've just seen in Blue Manchester are when we have the comfort blanket talking about emails and so on. And sometimes we see even worse things in witness statements when they stray into argument, into submission, into anger and frustration. And in Blue Manchester, His Honour Judge Stephen Davies really clamped down on this. He re-emphasized the importance of a witness statement, not including opinion evidence, not including argument. And this is the case even where allegations are made in a professional negligence claim or otherwise. The judge went as far as to say he did not accept that such circumstances would give carte blanche to disregard PD 32 or PD 57 AC by replying to the allegations in a way which includes argument, comment, opinion, and/or extensive reference to or quotation from documents. Taking a step back, I think what this decision and PD 57 AC as a whole highlights is the need to deploy argument in skeleton arguments and oral submissions. A lot of thought has to go into where you park the elements you need for trial and how to use that effectively. It is not for witness statements to give opinion evidence and make arguments.
Ruth, can you pull together correspondence, comfort blankets? When can we or can't we put in the story of the email chain?
Exactly, Marion. So I think it's the end of comfort blankets, unfortunately, in terms of email chains. The approach in the practice direction is clear. So paragraph 3.4 says a trial witness statement should refer to documents, if at all, only when necessary. So again, as you say, when you're drafting the statement, alarm bells need to start going if you are reciting a long line of correspondence. But again, His Honour Judge Davies was clear on this. He said at paragraph 38, it's the death of the comfort blanket. It's that paragraph effectively. And one can understand the concern. There's this temptation to put it in because someone thinks if I don't, it's going to disappear into the ether. It's going to be ruled inadmissible. I think that's all very understandable. But what His Honour Judge Davies did in Blue Manchester was he said, quote, a classic old style narrative recital of and extracts from a series of meeting notes and correspondence. Effectively, that's not allowed. So by all means, if it's relevant and it's needed, put it in. But the age-old approach of simply writing in a stream of correspondence, that can no longer be the case.
It's got to be necessary. Yeah, that's the key word. Okay, and what about what the witness thought or did at the time?
That's in a different category, but has to be approached with some caution. The helpful test is whether it's relevant. But I think at a more practical level, the way to think about it is if, for example, you have very detailed email chains which seem to cover or provide a contemporaneous record of events at the time, think seriously, is there anything that the witness needs to add or can usefully add beyond just saying the emails reflect this? Or the same for meeting minutes. If you think they're accurate, they will stand for themselves and they don't need to be embellished or glossed over. If anything, that could be unhelpful. So it's about filling in the gaps that are not already covered by the documents.
Yeah, it's about not wasting time. So two themes, isn't it? Let's be useful in our time. Let's work out where we're going to put this information in the pot of material in front of the judge, and let's also be able to reassure the judge of the quality of this witness's recollection. And let's just pick up on that to remind ourselves in the practice direction for important disputed matters of fact. The statement should, as far as practicable, so lots of little carve-outs there, state in the witness's own words how well they recollect, and whether and if so, when and how their memory has been refreshed. And I'm going to actually drill down one day as to how far we can actually articulate the process of refreshment. What are we talking about there? When does it cease to be refreshment and become recreation? Johan, guidance on that.
Yes, the courts have been clear that this is an important requirement. You have to respect that requirement. In Blue Manchester, His Honour Judge Stephen Davies made clear that a witness could not rely on their own subjective view of what is important to avoid compliance. I mean, it simply does not pass muster if you say, oh, I think this is important, I think this is not important. It has to be an objective view of what is important. And the court can, and I think the implicit warning is will intervene if it's plain that a fact on any objective analysis is important. And that's at paragraphs 40 and 41 of the judgment.
You wouldn't think it needed saying, would you? But it's there, it's been said. Now, question 3, list of documents. It caused huge controversy. It was the subject of so many questions when we ran these sessions 10 months ago. We know that the witness statement must list what documents, if any, the witness has referred to or been referred to for the purposes of providing evidence. Ruth, first question for you. Do all of the documents that a witness has looked at during the proceedings need to be listed? Any guidance?
So the answer is no, Marion, and we get a clear and helpful answer for this from Mrs. Justice O'Farrell in Mansion Place. And what she said at paragraph 59 is she said, this does not require the witness statement to list every document which the witness has looked at during proceedings. So a pretty clear, at least initial statement there from the courts.
But how do we judge what goes in, what doesn't?
It's difficult, Marion. So I think what's also important, again, it's all about context with these statements. And Mrs. Justice O'Farrell did go on to say, she said the purpose of the rule is to provide transparency in respect of documents. So that's the key. It should be clear for the judge what documents the witness had before them. Equally, it should be clear to the other side for cross-examination which documents the witness had before them. And it goes on to say that the court needs to understand the extent to which, if at all, the witness might have been influenced by contemporaneous documents, including those not seen at the time. Now, interestingly, on these particular facts, she said there's no indication that documents not referred to in the statements have been used to refresh memories. And she said that wasn't surprising in this case, because the key exchange in question was a telephone conversation. But she said that witnesses can be cross-examined about this at trial. So important to keep in mind the context of this case. The central issue was whether an oral agreement had been made during a telephone call. Both witnesses are going to give live evidence at trial. Again, the emphasis of let's hear it from the horse's mouth, so to speak. Let's hear the live evidence and let's hear what the witnesses have to say.
Yeah, and a really practical response, wasn't it? You know, no one's pointing to an obvious problem with this. Yeah, okay. What about the presentation of those lists of documents? I think Blue Manchester was quite illuminative in at least one thing we can't do.
Yes, I think it's fair to say that so far the courts haven't been particularly prescriptive about presentation, and I think that's maybe an area that would benefit from some additional case law. What we have in Blue Manchester is an example of things that have gone wrong, and what was done in that case was a composite list of a list of documents was prepared, and so this is essentially the same list of documents being used for multiple witnesses. And
sorry, just explain that to me again. There was one list?
It was one list used for multiple witnesses, yes. So rather than individual lists of documents for, you know, witness 1, witness 2, witness 3, the same list was used. And the second mischief was that none of the witness statements actually referred to that composite list either. So it was, and the judge criticized the solicitors responsible for not separating out the documents that had been referred to each witness. And the more general point is there shouldn't be guesswork as to what the list is. You should refer to it in your statement or append it. There may be some debate about how exactly you do it, but there shouldn't be any doubt about what the relevant list is.
Yeah. Can you ever use a composite list?
The judge said it's possible, but that would be the exception rather than the rule.
Yeah. Yeah. So if you find yourself drawing up a composite list, pause. Amber light. You may need to separate that out. Okay, let's have a look, I think, now at question 4. Some interesting questions are coming in, and I want to get to the Q&A session to pick up on some of those. What sanctions are being imposed? What's being struck out? How has the law changed? Okay, now, is the court going to necessarily strike out parts of witness statements? Johan.
Well, the short answer is no, based on what we've seen. So strikeout is a serious sanction. It is there, it can be used. One can imagine it will be used in an extreme case. But what we've seen so far is that courts have looked at the range of options available to sanction and looked at less harsh alternatives to strikeout. So by that, I mean cost sanctions, orders for revision of offending parts of witness statements, adverse comment or giving limited or no weight to certain parts of the witness statement while considering the rest of the statement in the usual way, and the like. So what we've seen in the authorities, in Blue Manchester, for example, the sanction applied there is revision of offending statements. In short, the judge said, go away, put it right, come back. And what the judge highlighted in that case is that the very significant sanction of strikeout is available, but it will be reserved for the most serious cases. And in that context as well, bearing in mind that Blue Manchester was decided last year when the PD was new, he said he was mindful that the witness statements were almost certainly prepared and in one case signed before the PD came into force. And he considered that these points were not an excuse in any way, but were a mitigating factor. What the subtext is, and where the direction of travel is that patience will run thin with offenders over time. I think the more we have a body of case law that develops, the less one can say, I didn't know, I didn't think about it. There have been ample warning from the courts. In Blue Manchester as well, at paragraph 45, the judge concluded that the proportionate sanction there was to impose an unless sanction as well. And the effect was to bite in relation to any individual sections of the individual witness statements that remain non-compliant in a non-trivial way.
Yeah, yeah. So even though he was taking a pragmatic approach, there was still the edge of that unless order. Although this was the second time at revision, wasn't it? There had been an earlier revision by agreement.
I think that's right.
Yeah, yeah. But it shows that you will be given space to get it right at the moment. Who knows how long that will continue. Costs, Ruth, have we had anything further, or are we still back into the final report of the working group?
We're still back into the final report. I think it's interesting looking at the case law that we have so far and looking at that final report. They do sing in some harmony. But on the cost point, what the final report of the working group said was, they said egregious cases should be singled out more frequently for judicial criticism and for cost sanctioning in order to encourage compliance in future cases. And the report went on to say, even if the quantum of the cost sanction imposed is not substantial, the fact of such an order coupled with judicial criticism is likely to have a, quote, beneficial effect. Now, beneficial is a little worrying there, but what they're saying is there will be cost sanctions, there will be sanctions in egregious cases, but the court isn't interested in unnecessarily doing it if people are trying to comply.
Yeah, there's very much that feeling of we're learning this together. You perhaps should have known it because we didn't change anything, but there's a space now to get it right. Can we just talk about the use of a non-solicitor? Because we were speculating whether or not that was going to sit with a statement of best practice. And we've had some guidance on that, Philippe, I think, from Mansion Place.
Yes, and Mrs. Justice O'Farrell confirmed that there's no prohibition on a draft witness statement being taken by a non-solicitor, but there are several cautions or safeguards that were added to that. And just going back, I mean, this point about there not being a prohibition goes back to a case from the early 2000s called Aquarius, a decision of Mr. Justice Toulson, as he then was. But moving forward to 2021-22, in Mansion Place, it was said that it was certainly inadvisable for a factual witness to prepare the draft statement of another witness. The obvious rationale is that there would be contamination of evidence and it may discredit both their accounts, similar to discussing evidence during a trial, which is prohibited. And on the facts, the key issue was what was or wasn't said by two individuals in a telephone call, and then related issues of credibility and reliability. So that's the context. The particular involvement here was by a claims consultant who had started to prepare the statements. The defendant's solicitor explained the approach under the PD by telephone, and particularly that the statement has to be in the witness's own words, confined to factual matters, avoid argument and submission, and not to comment in detail on documents. So all of the key requirements of the PD, and then the claims consultant produced first drafts of both his and the managing director's statement. These were reviewed by the solicitor and counsel, and there were remote meetings afterwards with the two witnesses. And the MD's statement was revised before service to set out words that he had used rather than paraphrasing. And the ultimate safeguard at the end of that would be cross-examination at trial, which would allow challenge. Personally, I would be extremely reluctant to follow this process just because employing someone else to do the initial draft doesn't get around the obligations in the PD. So this may not actually be very cost effective, or you may end up making an error which then can't be remedied anymore down the line in the way the evidence was taken.
Yeah, you've really got to have those good notes, because for me the big takeaway was it was revised back to use the witness's actual words. Now they had the notes to be able to do that. What would you do if you didn't have them? You could in fact have lost a potentially useful witness. So let's have a look. Questions. Question 5. How and when should issues about witness statements be raised? And I know that we've had quite a lot of guidance, I think, that should be able to help us get this right. Philippe, let's start with you and Mansion Place, which is the first time the court talked about it.
Yeah, I would say this is an area where the position is really clear now, and this part of the judgment I think should be required reading. Essentially, try to be collaborative and sensible. This isn't another forum for satellite litigation, and the specific reference is paras 49 to 50 in Mansion Place, where Mrs. Justice O'Farrell stressed that parties are encouraged to reach agreement. Failing that, make an application, which might be determined on the papers or at a hearing. And there's also the possibility of a matter being resolved by the trial judge, depending on the stage at which the point has arisen. And the key point is avoid disruption to trial preparation and racking up unnecessary costs. The courts will not look kindly on you for that.
So reach agreement, no satellite litigation. What's going to happen if parties fall into the trap of treating this as satellite litigation, Johan?
Well, Stephen Davis in Blue Manchester was very clear. He said those who indulge in unnecessary trench warfare in such cases can expect to be criticized and penalized in costs. I was quite intrigued by the word unnecessary, which suggests some trench warfare will have to happen. I think one has to be quite sensible about this. Bottom line is courts do not want this to spin off into expensive satellite litigation. On the facts of that case, the issues in relation to compliance with the practice direction were far-ranging, and all of that had led to a very expensive and hotly contested application. And what the judge said about that there is he said he hoped that PD57AC would become more familiar to practitioners. And as the principles become clearer, such heavily contested, time-consuming and expensive applications become the exception rather than the norm. So taking a step back, again, we see that very clear trend. The courts might understand why this happens when the PD is bedding in, but moving forward, that's not to be expected.
Only necessary trench warfare.
Quite.
Right, clear. We'll sum up. I think we've got 7 takeaways. We'll sum that up at 10 o'clock, but let's just get into some of these questions. And I'd like to take the first one, which raises, I think, questions about how we get this evidence in before the court, and also the application in the insolvency context, which we're all going to have to be thinking about as we come out of this pandemic. The question is this: in an insolvency context, I wonder whether there's any basis for a liquidator to put in a statement at all, given that, of course, they have no first-hand knowledge of what occurred. So the only way to get the evidence in is by having all the documents in the bundle, and then counsel has to, in effect, open the case and take the court through all the documents. Is that a cost saving? So does it apply to insolvency? I'm going to tease out of that. Does it imply in the insolvency context? How do we get this evidence in front of the judge? And are we saving costs? Okay, who wants to take the first one? Philippe, I think you know the insolvency context.
Yeah, I think the starting point, whenever you're dealing with specialist proceedings and you're in doubt as to, or maybe you should just double check, does the PD strictly apply? And where that's done is in paragraph 1.3 of the practice direction, and subparagraph 3 makes clear that an application for an order under the Insolvency Act, under the Insolvency Rules 2016, and some related enactments isn't covered by the PD, but there is the caveat that the court may direct at any stage that the PD does apply. And I think as a matter of practice, where you're getting closer to something that can be dealt in the conventional PD 57 way, a judge may well be inclined to approach it in that way. Where you're in a context where it would be, as in this example, artificial because the liquidator wasn't around at the time to give a narrative without reference to the documents, I think it's unlikely that the court would extend the PD. And to an extent, I think we can assume that the key exceptions were drafted with that in mind.
Yeah, let's talk now about the question, are we going to have to go back to old style openings? Where do we put the comfort blanket? If it's snatched out of our hands when drafting the witness statement, where does it now go? Any thoughts on that? Ruth, I know you've been thinking about that quite a lot.
Yeah, so Marion, I was spending some time thinking about this point yesterday because I was drafting a chronology and a dramatis personae for a forthcoming trial in the Business and Property Court. And the chronology, maybe I thought, didn't look quite as different as it might have before. It probably looked a little different. But I was definitely conscious as I drafted the dramatis personae that more information was going in there than perhaps it might have before. And of course, part of the reason for that was being conscious of the fact certain witnesses are not going to be able to speak to certain facts. We're not going to be able to put certain bits of information in their witness statements, and that has to go somewhere. So I think now this is obviously a trial that has started some way through the practice direction. But in future, when we're preparing for trials from the get-go, you would think about the extra documents all of that information might have to go into so that it's clearly before the judge in an intelligible way.
And Philippe, we were talking about the old style opening when you literally counsel took the judge through the documents. And I think you commented on the fact that you thought the commercial court, or at least part of it, was looking for that.
Yeah, the context was, this was at a Comm session introducing the new commercial court guide, and the way it came up was Mr. Justice Andrew Baker was explaining the revised approach to time estimates in the commercial court, where there isn't the strict separation anymore between reading time and trial time. There's a block of time, and in that context he said that could include doing a bit of pre-reading, then having an opening which takes the judge to some of the key documents, and then they might go away again and read some more, and then the trial would start in earnest. And it's in that context where, but I think I would look to have that discussion, say at the PTR, so that before you have to submit your skeletons, you get an indication from the judge how they want you to address this, and they might be generous and even allow. One thing Ruth and I discussed privately yesterday was having an additional document as almost a sort of document summary as an aid for the court. And I wouldn't recommend that as a matter of course, because it's not something that's usually permitted, but there must be some flexibility. If you get the judge to sign off, that may be something maybe in the course of trial that's produced or before closing submission. So don't despair. I mean, the court wants to have the evidence.
Yes, we must put it, Johan, just before we come to you, because you've taken a trial before Stephen Davis recently. What we must also, I think, pick up and we'll put into the list of cases is the use of the PTR. If this is a large enough case, they are going to expect you. Was that what you wanted to pick up on, Johan? Because I'll pass straight over to you.
No, it's actually a slightly different point. And I think that the trend in the BPCs, both PD57AC, we see PD51U, is very much to encourage all the parties, all the legal representatives, solicitors and counsel to think ahead and to front load some of the work. And my point is a simple point. If you think that your particular witness statement has particular features that make it inappropriate to apply PD57AC, that's a point you need to raise at the CMC. And I had exactly the same situation last year before Andrew Baker J, who was in very many ways the person who was driving this PD, and he gave permission for that particular witness not to be subject to PD57AC. So I do think do not just sit down and fret and think the facts don't fit how the PD works. The PD is meant to serve the justice of the case. And if you think it doesn't work, that's a conversation to be had between solicitors and counsel to be addressed at the CMC to make it as user-friendly as possible to have a fair and efficient trial. And in that case, Mr. Justice Andrew Baker was very happy to dispense with a witness being subject to PD57AC.
And in fact, that's the perfect answer to one of the points in the chat box, but how does the practice direction work with the disclosure pilot scheme in terms of practicalities? That's it's a great question. And it's one you've got to answer for each case as you're setting out down that disclosure pilot scheme, working out how you're going to be operating that. Think all the time, how am I going to fit this in with the witness statements? And if I've got issues, bring them to the court. They are not there to block the achievement of justice. You've heard it from me first. There's a really good point that's made in the chat. It's a fun point, and it shows you how you can never put a good lawyer down, because the point is made. Okay, so no comfort blankets, right? How about footnotes? Can I footnote? It's in the chat. It came in at 9:38, and it says, is it appropriate to reference in the body of a witness statement, text contains footnotes and footnote references? Can we reference documents that support or evidence the point being made? So basically, I'm not going to quote it, but I'm going to reference it. And I'm going to drop it into footnotes. Good lawyer, playing with the rules. Anyone seeing this? What do we think?
I don't think I've seen it, but I wouldn't recommend it for one reason. The statement of truth applies irrespective of whether you put something in the body of the statement or in a footnote. And I just think if you did this heavily, maybe one or two footnotes across a long statement is one thing. But if there was this impression that you were trying to use footnotes as a workaround to the PD, I just think that wouldn't go down well. And there's a question mark over whether you can properly sign off that this is a PD compliant statement.
If you've got a nervous witness, they're going to want, I mean, the formalities are, I think, increasing the pressure on the honest, decent witness who does not want to get into trouble and who wants to ensure that they're fully compliant. Now, they always were concerned, and now they're having to focus on that. Let's have a quick, anyone else got any comments on footnotes? I mean, we're all used, and it's wonderful to get the statement to which the references to the relevant documents are written in handwriting down the far margin as part of the trial preparation. Anyone else got any other comments about using footnotes?
Yes, Marion. So I'd agree with Philip on that. I mean, the odd footnote, I think, could be fine, but I think what we need to look at practice direction 57AC and think is it's not meant to be an answer to all questions. There are loads of different ways of approaching this exercise, and the practice direction at this point of the commentary doesn't provide a yes or no answer to all of those things. So we need to keep in mind the overarching purpose of this practice direction, and the purpose really is to stop statements being overly lawyered. Now, of course, if it trespassed into there being so many footnotes or hyperlinks that all of us as keen lawyers would think this looks like a very normal document to me that I'm well used to looking at, I think we need to think, would this witness use all of these footnotes? Does it look slightly odd in the context of their evidence? And if too many of those goes in, my concern would be it risks overstepping that line. Again, context specific, but that would be my concern.
Fact and degree, isn't it? Well, the other question that's been raised is, well, should we be videotaping? Should solicitors videotape? And it's also in the chat box. Should solicitors video record the evidence they take from their clients and then transcribe the evidence into a witness statement, which it may already be being done? What's your views on that? And Prince Andrew, I hope, is not on this call.
So just a first answer on that, Marion, Prince Andrew aside and the merits of individual witness statements and all that, my concern would be that what this best practice can do sometimes is the very conscientious witness, it can make them quite anxious about the process. And we all know what that's like anyway. Even though a witness is just a witness, they can start to feel like they're almost on trial. My concern on that proposal would be, depending on the witness, and certainly if that was a practice in a firm, I can imagine that would make some witnesses quite nervous. I'm not sure it would always be conducive to getting the best evidence from someone, for good or for bad. So that would be my initial concern when I see that. It's an interesting suggestion, but I'd be concerned about the kind of impact that might have on the evidence that you get. Yeah,
it'd be the time at which you introduce that notion perhaps might be key. But look, I'm acutely aware of where we are on time. What we're going to do, and I'm saying this, I hope so that I make sure this happens, we will capture the questions that have come in through the Q&A box and through the chat, and we will think of a way of actually addressing them individually. Leave that with us. We'll make sure that everyone who is on this video gets a note as to how we're going to deal with them. It may be we invite you to sort of drop onto a sofa and have a cup of coffee and talk about it on Zoom. We'll think about that, but can we just now try and pull it all together? So we have got, I think, 7 takeaways, and Ruth, you're going to go first. What are your 3?
Yeah, so my 3 takeaways, Marion, the first is that although some of this all might seem quite difficult, the practice direction, it's not meant to change the law as to the admissibility of evidence at trial. Again, as Philip said, the courts want to be helpful. They want to have the best evidence. And in light of that, existing case law on admissibility remains good law. The second point that I would highlight is that the purpose, again, of this practice direction, it's meant to eradicate the improper use of witness statements. And I think some of the biggest offenders that we've seen in the case law, it's narrative, commentary, argument. If you see that going in, again, big alarm bells ringing. And the final point I would highlight is that when preparing the list of documents, be transparent about the documents used to refresh memory of the witness. There's nothing wrong with including something. There is something wrong with someone having a suspicion that all of those documents having been listed. So again, caution on that point would be my advice.
Philip, over to you.
The fourth point is the court and the other parties are entitled to understand the extent to which, if at all, a witness might have been influenced in the witness-taking process by contemporaneous documents, and that includes documents not seen at the time. And relatedly, as we discussed earlier, the degree of recollection and source or sources of information should be stated as clearly as possible.
And Johan, play us out.
Yes, 6th point, if you have any concerns about your opponent's compliance, raise it in correspondence in the usual way, do it efficiently, try to be cooperative, and if it doesn't work out, you can make an application, but do it in a cost and time effective way. It may be that the appropriate judge to rule on that would be the trial judge by that stage. Last point, be mindful of the potential sanctions for non-compliance. Strikeout has been bandied about. Strikeout is an option. Strikeout will be reserved for extreme cases, but strikeout is there. Don't let it happen to you.
Go forth, produce your witness statements. Don't panic. I'm not going to use the cliche, keep calm and carry on. I'm not going to use that. Work with your opponent, work with the courts. It's all in the service of the rule of law. Great, great. Thank you so much for participating. And as I say, we'll get back to you all as to how we're going to answer the other questions. Thank you so much for participating. Thank you. Thank you.